Our next, well, actually, before I introduce our next speaker, I do want to recognize that we have been joined by another board member, Ed Grant. And now our next speaker is actually Jerry Bradley, who is a member of our advisory board, so double treat for us, and his wife Pam is here with him. So welcome, Pam. Jerry Bradley is professor of law at the University of Notre Dame, where he teaches legal ethics and constitutional law, and along with John Finnis, directs the Natural Law Institute and co-edits the American Journal of Jurisprudence, which is an international forum for legal philosophy. He received his BA and JD from Cornell, summa cum laude from the law school. He practiced as a prosecutor in Manhattan, and if you know him, you know that was a good personality fit. And he taught law at the University of Illinois for many years before joining Notre Dame. He's published over 100 scholarly articles and reviews in several books. I've said this in front of his students, so I can say it in front of you. I think he's perhaps the best constitutional law scholar in the country. So, Jerry.
Well, thanks very much, Bill, for the introduction. I'm not sure what to make of the comment about being well-suited to being a prosecutor in Manhattan, especially since there's a fact that Bill didn't share with you, which may be relevant to his comment, and it's that I specialized in pimp prosecution. But I want to say nonetheless that it's a special treat for me to be introduced by my friend Bill Saunders, who, given his work over decades now in freedom of religion, pro-life work, pro-family work, has really become a model to so many of us, including myself. I should say that perhaps I first began to work very closely with Bill, well, probably in the late 1990s, when he was doing something entirely unrelated to those particular causes. He was organizing people in America to help our suffering and persecuted brethren in Sudan. And for many years, Bill, he founded and ran for many years the Bishop Gassi Sudan Relief Fund, which was at the time desperately needed, since few, if any, other organizations were taking the risk and traveling to southern Sudan, which was then a war zone. And I know that at one time Bill was on a trip there on behalf of our group. I believe it was Christmas Eve or Christmas Day, and Bill was bombed along with the rest of the people who were attending Mass with him in an African village. But one word about AUL before I get to my talk today, which is about persons and the law and abortion. Just last weekend, Pam and I went to Chicago for an evening play and decided to stay overnight, so we stayed at the Palmer House, Hilton Hotel now. And it reminded us of what I think is our only other stay at the Palmer House in Chicago, which was in the spring of 1984, and the occasion was an AUL conference. And we attended the conference. And I remember, by the way, that the keynote speaker that day was an Oxford Don, a legal philosopher named John Finnis, who has since, over the last 15 or so years, become, as Bill mentioned, my own collaborator at Notre Dame. But it makes me realize that under the leadership of Clark Forsyth at Grant, way back Vic Rosenblum, AUL has been in the forefront at the head table of the pro-life fight, and it's stayed the course. God willing, it won't have to stay the course another 40 years, but that's really the most or highest compliment I can think to an organization in this cause, is just staying at one's post. And Charmaine has taken the organization to even greater heights or more prominence, and I'm just very pleased to be asked to be part of this group. Now, abortion is, I submit, the greatest civil rights issue of our time because it raises uniquely and compellingly the foundational question about law and justice which every society faces. It is the question, who is the law for? For whose benefit do we plan and build and apply this vast apparatus we call the rule of law? Now, this question is foundational because it is prior in status and importance to the question, what shall the law be? It is foundational because answering it right is essential to justice. Anyone can see that even the most refined arrangement of legal rights and duties counts for naught if the strong can, with impunity, manipulate the foundational question, deny the benefits of law to those they wish to exploit. Now, legal thinkers as far back as the 6th century, and I'm thinking of Justinian, saw correctly that law is for persons, not the other way around. Persons are the point of law. Law is their servant. Persons are not for the state, for the fatherland, or for the glory of the common law. These beneficiaries, these persons, are not entities identified through policy analysis. They're not the sums of interests balanced, the deliverables of a vast progressive agenda. These older jurists saw, too, that the question of personhood could not be and was not an intra-systemic riddle solved by a feat of technical legal reasoning and answered with a legal fiction or a term of art, as if the law could be as impervious to the reality of persons as Chancery was to the reality of justice in the case of Jarndyce versus Jarndyce. Being prior to law and indispensable to justice, the foundational question must be answered according to the truth of the matter. Everyone who really is a person has to count in law as one. Now, clear-headed thinkers through the centuries would have gasped, therefore, at the legal philosopher Ronald Dworkin's view that the question, who counts as a person, is like a membership application to the Rotary Club. Dworkin said, do those who already count want to open up the membership rolls, as if justice was not demanding anything of us. These thinkers would have been staggered by John Rawls's argument, Rawls, the leading political philosopher of the last 40 years, his argument that a just abortion policy for America is that policy which respects the rights of everyone who's party to the argument about abortion, their right to be heard respectfully. Rawls already subordinating a fundamental issue of justice to a secondary or tertiary one, subordinating protecting persons' lives to civil discourse. And these people, and we should too, naturally reject President Obama's message on last year's anniversary of Roe versus Wade, when President Obama said, we must continue our efforts to ensure that our daughters have the same rights, freedoms, and opportunities as our sons to fulfill their dreams. Now, the President spoke, utterly without irony, only, of course, about sons and daughters who survived the womb. Besides, no one's son has anything like the rights, freedoms, and opportunities of everyone's daughters when it comes to the life or death of their child in the womb. And Justinian, these thinkers going back to the 6th century, would have been horrified by the pettifoggery of the Roe Court, which set upon the foundational question about persons with the zeal of a clerk and with the charity of a highway robber. The Roe Court asked itself about constitutional persons, knowing that this was the foundational question, knowing that if the unborn counted as persons within the meaning of the 14th Amendment, the case for abortion would, this is the Roe Court's term, collapse. While Harry Blackman and his confreres set about to resolve that through a feat of technical legal reasoning, impervious, and it would seem blithely indifferent to the truth of the matter about persons. This is the same court that seemed to rejoice. I take that back. It rejoiced and congratulated itself for not needing to resolve the difficult question of when life begins. This was a court that undertook to authorize the use of deadly force upon a class of beings, human beings, without ever concluding that the victims were not really persons. And note well, nowhere does the court in Roe, nor at any time since, has the Supreme Court said flatly, the unborn are not persons. The court tried, in other words, to suppress the foundational question, who counts as a person? as Dworkin, Rawls, Obama, and so many other people have tried to do. It's the great accomplishment of the pro-life movement, it's a great accomplishment especially of this organization, to have resisted this suppression, to have kept alive the spirit of justice, and to have promoted in season and out of season a willingness to face unafraid the demands of justice. The fruits of this effort, along with the revelations of neonatal and genetic science, and some important legal successes, provide, in my judgment, a new opportunity now that is at hand to exploit a portentous, maybe fatal flaw in Roe versus Wade jerry-rigged legal edifice. This limitation arises in the heart of Roe, and it illumines the way to an eventual, hopefully soon, near, Supreme Court reconsideration of Roe on terms favorable to the pro-life cause. Now, the protagonist of this possibly epic Supreme Court reconsideration of Roe will not be a good Samaritan or heroic state official. He will be a bad man, one who has killed his own unborn son or daughter, a man like Scott Peterson, whose present address is Death Row, San Quentin Prison. This protagonist's aim will not be the aim which has brought many thousands of people to D.C. to march tomorrow. This protagonist is no champion of human rights. He will simply want his conviction for what is generically called feticide reversed. But his constitutional arguments will nonetheless force the justices to confront, as they have never confronted before, the foundational question: who counts really as a person, the question they suppressed in 1973. Now, the protagonist could be Airman First Class Scott Boye, B-O-I-E. Boye married his girlfriend shortly after learning that she carried their child. But he was never happy about the pregnancy, and before long, he asked his girlfriend, now wife, to have an abortion. When she refused, Boye bought some misoprostol, an abortifacient commonly used in lawful chemical abortions. He ground the drug into a powder and secretly put some of it into his wife's food and drink on 4 separate occasions. She soon miscarried. After admitting what he had done during a recently recorded, or I should say secretly recorded, phone conversation with his wife, he pleaded guilty under the federal Unborn Victims of Violence Act, pled guilty to the lesser offense of attempting to kill his child. It was a plea bargain. He was dishonorably discharged and sentenced to 10 years in prison. Or our protagonist might be Gerard Flores. By the time his girlfriend, Erica Basaria, discovered that she was pregnant with their twins, it was too late. Her physician said that neither he nor any other local doctor could safely perform the abortion both she and Gerardo wanted. Now, Basaria testified at Flores' capital murder trial that she asked him repeatedly to help end the pregnancy by stepping on her abdomen. He did so repeatedly. She, that is Basaria, even supplemented Gerardo's efforts by striking herself in the stomach every day. Now, none of it worked, at least immediately, but she later delivered stillborn twins. Flores was convicted of murder and sentenced to life in prison. Basaria was not prosecuted. Now, 38 or so states have enacted what, again, I'll generically call feticide laws like these since 1973. This effort, which I'm eager and pleased to note, was spearheaded by AUL, coordinated by AUL, and especially by its longtime leader, Clark Forsyth. These feticide laws are a great credit to many, many people, known and unknown to history, but including AUL and Clark. The federal law is typical. Many of you know what it says in pertinent part, but some don't, so I will summarize. In pertinent part, Federal Unborn Victims of Violence Act says, whoever causes the death of a child who is in utero is guilty of an offense distinct, separate from any accompanying offense against the woman carrying the child. This separate offense is subject to the same punishment as would be the identical misconduct if it were committed against the unborn child's mother, which would be the same punishment as if the offense, the same misconduct, were committed against anyone else, me or you, or Austin Roos, or Clark Forsyth, and Bill Saunders. Now, of course, in Roe itself, and I should say that these laws are based, in a sense, in Roe itself. And this is why I call this aspect of Roe a flaw. Because Roe congratulated itself for not resolving the question of when life begins. It found a right to abortion by identifying certain detriments or distresses that a pregnant woman might face. But even in articulating a right to abortion on demand, the Roe court never said the unborn are not persons. They said, well, the state may not adopt what Roe called a theory of life, such that it overrides the demands placed upon pregnant women, or overrides the rights of the pregnant woman. But in Roe, and as many of you know, in Webster in 1989, and again in Casey in 1992, with not a word contradicting this since, the court has said repeatedly, apart from this immunity, you might say privacy, or cocoon, or liberty around that woman, the state is free to adopt, if you wish to call it that, a theory of life. The state is free to affirm that people begin at fertilization, that from the get-go, these persons have the same right not to be killed, and it's good against the whole world in exactly the same ways it's good against us, for us, with the one exception, the woman aborting. Hence, the solid constitutional foundation of all these feticide statutes. And I submit it might be the undoing of Roe, because Airman Boy, Gerard Flores, and the many other defendants convicted of feticide make an equal protection argument against their convictions, to overturn their convictions. They say it violates equal protection of the law. It's unconstitutional to hold him accountable for what she is perfectly free to do. They say, in effect, but this is clearly what they're saying, I'm making the same choice, I have the same intention, commit the same act, cause the same harm, engage even in the same behavior, whether it's an abortifacient drug or stomping on somebody's stomach, and I can have the same motivation, and did, these men say. After all, the detriments, the court's word, the Roe court's word, which underwrote the abortion liberty, are not really about pregnancy, right? Only one of the 7 challenges the court identified or cataloged in Roe as the substance or the foundation for an abortion right had to do with the child in the womb, one of 7, medically diagnosable harm during pregnancy. All of the other reasons adduced in Roe for abortion liberty had to do with the anticipated burdens of raising a child. These were, now I quote Roe, maternity or additional offspring may force upon the woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by child care. There is also the distress for all concerned associated with the unwanted child. And there is the problem of bringing a child into a family already unable, psychologically and otherwise, to care for it. The court also mentioned the stigma of unwed motherhood, but that's evaporated since 1973. And the remaining detriments are real enough, and despite the use of the word woman or maternity, none of them is gender specific. None of them, not even all of them together, would morally or legally justify any mother or any father or anyone else in killing a child who's already born. And all of these distresses or detriments can be presented to the father of a child as much as or more so than in the case of the mother. So Airman Boy, Flores, and the others who have been convicted of feticide say it won't do, and it violates equality, to declare that he, boy, Flores, is never justified in seeking to avoid these harms by exactly the same means, by doing what she is never asked to ever justify, namely killing their child unborn. He and his peers argue that once the legislature has decided to treat the unborn as homicide victims, the law may not hold him responsible while completely exempting her for doing the same thing. It is not, and they readily recognize this and allow it, that the presence of the child within her womb, not his, makes no difference. It does. And so if the pregnancy itself threatens her life or her bodily health, then her abortion might be legally justified, if not morally justified. Even so, Boye and Flores and these guys say that the pregnancy difference itself has to be subjected to the same law, the same norms of justification and excuse. Pregnancy matters, but it has to be evaluated according to the same law that his act is evaluated according to. Similarly, all of the other detriments mentioned by the lower court. Now, I've already mentioned that the majority in Roe will congratulate itself for being philosophical idiots, or with no desire to be charitable in this particular way. Perhaps we can more charitably say being philosophically reticent, for abstaining from philosophy. And I mean by philosophy nothing highfalutin, just a matter of looking at reality and trying to reason to a conclusion about when people begin, which is actually not that hard to do, to be honest with you. But I also mean here now to say in conclusion a word about let's call them, without naming names, just call them the conservatives on the Supreme Court, this court now, who have been people, maybe a couple of them especially, who have been themselves philosophically reticent. There's a way in which judicial conservatism is identified with an aversion to what they would call judicial philosophizing, judges making value judgments, judges imposing, if you will, their policy preferences. So hold that thought. The conservatives on the court being not responsible for Roe, not at all, but rather being themselves philosophically reticent. I think it will be awkward then for the entire court to now take up the foundational question it has long suppressed. Who counts? Who's a person? When do people begin? But I think the justices actually have no feasible alternative. Ehrman Boye and the like raised equal protection challenges which go right through the personhood question. These challenges deserve a conscientious response. Now, the court's not obliged to take these cases. They can grant cert or withhold it, that is, deny cert. And you can run for a long time from the demands of equality. And maybe you can hide for a while, but I don't think you can hide indefinitely. Now, it may be scarcely imaginable, I think it's almost unimaginable, that the court now would declare, for the first time, flatly, the unborn are not really persons. They're not human life deserving respect. In truth, people don't begin until birth, and that these judgments, people don't begin until birth, the unborn are not persons, they're conclusive upon state legislatures and Congress. I think it's almost unimaginable that the whole feticide regime and everything that goes into it, all of the recognition, all of the judgments, all of the science that have given rise to the feticide regime, recognizing that people begin at fertilization, the court just pushing all of that over, revolutionizing this part of the law, well, it's scarcely imaginable. I think it's scarcely imaginable that the court could escape the dilemma presented by these feticide defendants by declaring, for example, the Act of Congress, the Unborn Victims of Violence Act, unconstitutional. These are now permanent fixtures of our legal system. Sonograms, prenatal medical developments, DNA research, replenished common sense all show that these laws are well-founded. People do begin at fertilization. But to say scarcely imaginable is not to say quite unimaginable. And the pro-choice dogmatists on the court might yet cling tenaciously, that tenaciously, to abortion rights. They might venture into the philosophical deep and sweep away this latest threat to what they consider to be the non-negotiable demands of women's equality. So perhaps then the paradoxes of persons that I've described the ones raised by the feticide cases in light of Roe, have greater purchase upon the court's conservatives, upon those justices who recognize the injustice of abortion and who have long regarded Roe as an albatross around their necks and as a stain upon the court. Now, these men profess varying degrees of faithfulness to the original understanding of constitutional provisions, and I will simply state flatly and defend, next time Bill invites me to defend it, that there is no doubt that the plain meaning, original purpose, and original understanding of the word person in the 14th Amendment, where no state shall deny equal protection of the laws to any person, there's no doubt that word referred to the entire reality. That is, the meaning of the Constitution in that particular instance, person, is the same as the reality of the matter. But again, that's the original understanding, and I think in this case, the originalism of these justices should call them to make what they might call a value judgment. But they've shown little inclination so far to do that in this case. Of course, the position of the conservative justices is that the Constitution is silent about abortion. One state can have pro-choice laws, another state can have pro-life laws. It just says the Constitution has nothing to do with abortion. I think that view is mistaken. But their characteristic philosophical reticence is usually well-founded. Not this time. Usually is not always. And if not now, when? When would it be right for these justices to step up and take on this question, call it philosophical? For abortion is not only the great civil rights issue of our time, it is the greatest human rights tragedy in America's history. And it is so by far. 55 million dead since Roe and counting. That's 100 times more than all the Americans killed in battle during World War II. It is many millions more than all the Africans ever enslaved in America. And these 55 million were killed outright. They were killed before they could come to know a mother's love or a wonder at a sunset, before they could praise God, as even the slaves could and did.
We have, I'm watching a clock. I think we have time for a couple of questions if somebody wants to ask one. Ed, go ahead.
Professor, thanks. Professor, you've really touched on an issue that those of us who've been in the movement for a while know the struggles we've had over personhood. So I'm going to, since you mentioned me by name, please indulge me in the privilege of a multi-part question.
Permission granted, Ed.
Thank you. Is it possible, in your view, to enact, defend, philosophically, legally, laws that would restrict and even prohibit abortion without declaring the unborn to be persons or recognizing that under the 14th Amendment that they're considered to be persons, which I think is potentially a different issue. You could have legal personhood and then specifically what the 14th Amendment meant to cover, as you know, and I'm sure you've written about. So in other words, is that essential? I think there's a camp in the pro-life movement that has long said that declaration that the unborn are persons is not only necessary but is sufficient to resolve the whole issue. There's other camps that say it's not necessary and it wouldn't be sufficient, and that's been a tension within the legal side of the pro-life movement for quite a while. And then, of course, you know, what is it a legitimate? I think you're saying that it is a possible originalist understanding of the 14th Amendment that would include the unborn. Do you think that's the only legitimate reading of the 14th Amendment, or whether that's debatable. So I'm sorry for the multi-parts, but
No.
you've really raised issues at the heart of everything. Oh, and finally, a regime of a regime of abortion, regime of laws against abortion. Should they simply be fetal homicide laws that cover this situation, or do you think specific laws covering abortion would be necessary?
Well, they're all, I mean, thank you for your questions, Ed. They're all good ones. Let me take a stab at responding to a couple of parts of what I think you said. One is that I, for the moment, eschew discussion of tactics and strategy. So I'm not suggesting that personhood amendments are the way to go. I think actually in this particular climate, given our political and legal culture, they're probably too provocative and too clumsy. The other thing I would say about personhood amendments, which I think most of you must know, but perhaps not all of you do, are simply flat-footed declarations. One was recently attempted in Oklahoma, there's been one in Mississippi, but they basically just say, as a state constitutional amendment, people begin a fertilization and have the rights of other people from that point forward. What I would say about those efforts, besides I think they're provocative and so far have not been as successful, is what do they do that feticide laws don't do? And that maybe is the heart of my response to your question is, well, do we have to declare them persons? What can you do? Well, what do the feticide laws do? Let's ask Scott Peterson next time we can ring him up on death row and say, when do you think the law of California has decided people begin, Scott? Or Airman Boy? Our law is chock full of declarations of when people begin. And those declarations have the same meat and substance and effect when applied to you as applied to unborn children. I mean, I'm not really sure what else the law is supposed to do, because I think the central goal of the pro-life legal movement has always been to find a way to bring, or I should say assimilate, abortion to the ordinary laws of homicide, which means to bring the abortion decision under the governance of normal, that is, ambient principles of justification and excuse. You wouldn't quite say that the aim of the pro-life legal movement has been to eliminate abortion. It would be good if that happened, but I think that the goal has been to treat it like another form of homicide. But that would include applying principles of justification and excuse. So for the life of the mother, sure, that would be at least legally justified, if not morally so. But I guess my point is, I'm not sure what else should be done to make that happen that's not happening with the feticide laws. Now, you've got now the arbitrary block of Roe. And for that reason, you have written into the federal feticide law, the Unborn Victims of Violence Act, you have an exemption or an immunity for the pregnant woman. But that now appears to be, what, more and more logically, and as a matter of justice and humanity, a derelict, an anomaly. And as one law professor who testified in favor, I think this would be 2004, of the Unborn Victims of Violence Act, I can remember very well what this particular law professor said, testifying in Congress. Well, if there's an anomaly in the law created by passing this Unborn Victims of Violence Act, it's an anomaly in Roe, not in this law. And I'm not really sure, in a way, I don't want to be heard to suggest implicitly, well, we've won. You know, the pro-life goal has been reached. We have justification principles clamped down in favor of the unborn, except for this huge exception, 1.3 million times a year. But the tools are there, and I think I do want to be heard to say, right now we're looking at power blocking the momentum of justice. I mean, the predicates and premises are in place. Now, power is in the way, and power is not to be trifled with, and it's no joke. But I think it's power at this point, just arbitrarily declaring, judges, justices, the president, this is what we're going to have here. And we're not going to argue with you anymore about persons. And of course, that's one of the great victories of the pro-life movement, really, is that they don't argue with us about who's a person anymore, right? When was the last time President Obama, just for example, among many others, took up that question in some kind of forum?
Anybody else? Any other questions?
Fascinating presentation. Oh, introduce myself. I'm Star Parker with CURE. These protagonists that you mentioned, perhaps I missed it in your presentation, are they making this case? First part. And number two, are you saying that in Roe they're not mentioning that a medical or doctor has to be present?
Oh, as to the second point, no, I'm not suggesting that. So that one of the cases, Gerard Flores, where he and his girlfriend, Erica Basaria, seemed to be conspiring to produce a kind of crude abortion by stomping on the stomach. Now, she was not prosecuted, but in some jurisdictions, she could have been and would have been. I mean, what you're entitled to after Roe is to perform a lawful or be party to a lawful abortion. So in my own home state of Indiana, the law about abortion pretty much reads this way: all abortions are crimes, except, and then there's a long list of regulations where a woman with consent and voluntarily goes to a licensed place. So basically, the structure of the abortion law is that there should be no abortions, with this huge exception. But that's not necessarily true everywhere, and some feticide laws will immunize the woman completely. Sometimes they will more explicitly limit her just to pursuing a lawful abortion, that is a surgical abortion, let's say, so that Erica Basaria could have been prosecuted in some jurisdictions. But as to the first, these men, and there are many others, are challenging their convictions. Their convictions are always affirmed, and the laws, the feticide laws, are always affirmed. The courts recognize exactly what the problem is, what the threat is. They see that Roe is now exposed. And here's a situation where I am not charitable towards the judges in these cases who are affirming the convictions. That's not what makes me uncharitable. But rather, when they see what these men are saying about Roe and equal protection and them, and the norms of justification being applied to them as they should to her, they struggle, to put it very charitably. These judges, in case after case, the Flores case, Boy's case, the best example is Commonwealth versus Bullock, Pennsylvania case, a feticide defendant, Matthew Bullock. He says, you can't convict me unless you change the law so that she has to pony up and justify what she's doing. The court says, nope, we're just not going to do that. Arbitrarily suppressing the force or evading the force of the challenge. And if you want to, not laugh, because that's inappropriate in this context, but if you want to have a funny feeling inside, read the concurring opinion by Judge Baer, B-A-E-R, in the Bullock case. And here's a man who knows exactly what logic, coherence, and justice require. He sees that Roe is maybe fatally exposed, and he simply, now I'm going to do from memory, Baer just says, well, the legislature is not going to undo Roe by playing word games in the feticide law. The law says people begin at fertilization, so that's a word game. But he says any attempt to use the feticide law in this case, or any other like it, to undo Roe, and here's his exact phrase, is unavailing. Okay, that's the judge's term, is unavailing. Now, I know what that means. He's saying, you ain't going to get away with this. We're going to block you. But there it is. It is being blocked. We're being blocked. But that's the nature of the counterforce. It is just force. Is unavailing.
Okay, go ahead. We've got time for one more.
Carol Grosset asking you about the word game, the difference between a human being and personhood. I debated pro-choice advocates, and they'll say, well, yeah, it's a human being. I mean, it has DNA structure like you and me, but it's not a person. Personhood is a metaphysical term.
Right. That's correct. I mean, that's correct. And sure, Roe, well, I don't know, Roe doesn't quite, well, leave aside whether Roe concedes it's a human being, but everybody now does, right? Everybody knows it's a human being. Left undisturbed and given a proper environment will become Ed Gaffney, for God's sake, the man next to you. But I mean, I suppose in effect, Roe did us a disservice, to say the least, by separating the human being from the person. And, you know, I've debated, maybe not as often as you have, but I've debated this issue. And the great problem in their position is to separate human beings and persons. And they want to say persons don't begin until much later than the human being begins. But they can't ever manage to do that and limit the collateral damage just to unborn people. Every time you make them identify, well, what is it besides the existence of the organism and the full DNA complement, we can see that the whole direction is to become like Ed Gaffney or Charmaine Yost. We can see all of that, and you agree with all of that. So what is it that's missing then that you say when it arrives changes the human being into the person? Let's say consciousness, sentience, the ability to have interests, to have projects. They have all sorts of possibilities, but they've never been able to establish that. They can't establish it convincingly for other reasons, but on a simple dialectical level, they can't avoid condemning some other folks, walking around folks, whether they're mentally debilitated, whether they're sleeping, if you talk about consciousness, whether they're like infants. The problem with all of their arguments is that they can't get what they want, which is basically unborn human beings are fair game, at least for their mothers. But everybody else, basically, well, it's business as usual. We're all fine. Well, given their unfortunate attempts to separate person from human being, they identify person with some, effectively, subset of all of us walking around. I think the thing to do is for all of us to maybe stop buying green bananas if they have their way.
Okay, thank you, Jerry.